Interim attorney's fees versus contribution to attorney's fees in an Illinois divorce. Divorce is expensive. In Illinois, attorney's fees during and after a divorce often run into thousands of dollars and must be paid. Illinois law recognizes that a spouse, ex-spouse or other parent can ask their partner to contribute to legal costs on a temporary or final basis. The law addresses fairness by allowing courts to shift fees so that one side is not financially crushed and the other is empowered to drag out litigation. This discussion explains how interim attorneys' fees and contribution hearings work and why they matter. Illinois courts have statutory authority to order a party to pay a reasonable amount for his own or the other party's costs and attorney's fees. Without this right, a moneyed spouse could always prevail because the non-moneyed spouse would be unable to continue paying counsel. Attorneys themselves have standing to pursue fees in divorce cases. There are two ways to seek payment: an interim fee, which is requested before the divorce is final, and a contribution hearing after the trial. Each path has different proof standards and strategies. A knowledgeable lawyer can explain these options and help you prepare the required affidavits and evidence. Interim fees. An interim fee is a payment ordered from one spouse to the other before the divorce is concluded. Interim fee petitions are heard on a summary basis without testimony. Judges review the parties' financial affidavits and hear argument. Although the statute lists numerous factors to consider, ranging from income to standard of living, courts often focus on the amount each side has already paid to lawyers because it is easy to verify. To level the playing field, a judge may direct the spouse with greater resources to reimburse the other for what they have spent on their lawyer. The goal is to prevent an economically disadvantaged spouse from being forced out of the case. Interim awards are temporary and can be adjusted when the case is fully tried, so any missteps in the summary hearing are addressed at the later contribution hearing. Contribution hearings. After a divorce trial, a party may ask the court to have the other side contribute to the fees incurred. The petition must include the bills generated during the trial, and it generally must be filed within 14 days after the closing of proofs unless the judge extends the time. Final fee awards are based on the same criteria used to divide marital property and award maintenance, so judges have broad discretion and need not make detailed findings. Awards are typically lump sum amounts. Statutes allow percentage awards, but those are seldom granted. Contribution hearings can occur whenever a family law matter is effectively over, not just after a trial. Post-judgment and unmarried parent cases. Unmarried parents never get a divorce trial yet can still seek attorney's fees. The Illinois Parentage Act authorizes courts to order reasonable fees and costs in pre-trial, post-judgment and appellate proceedings. Before a divorce is finalized, identifying whether the request is interim or final is straightforward. If no trial has occurred, it is interim, and if a trial has occurred, it is final. Temporary fees in post-judgment matters may be heard on a summary basis, and case law permits final hearings even after the decree. Illinois statutes give courts wide discretion. A seasoned attorney will tailor the strategy to your circumstances, and understanding the law helps you advocate for your rights. For further guidance, consider speaking with a family law attorney familiar with Illinois practices. Choosing the right counsel ensures your voice is heard. The law office of Russell D. Knight represents clients throughout the Chicago area. To discuss who will pay the attorney's fees in your Illinois divorce or parentage case, visit our law firm at 1165 North Clark Street, number 700, Chicago, Illinois, 60610, or call 773-334-6311. Our law firm aims to protect your interests.